Well, hi everyone, and welcome to another episode of Club Grubbery. It's the 13th of May. We're recording this one. John, good to see you back.
Thanks, mate. Great to be here.
We just did an interview a couple of hours ago with Senator Ron Johnson from the USA, and boy, that was a pretty good interview. And we know this one will be an interesting interview too, because we've got as our special guest today the Susie Quattro of the Australian legal scene, Jacqui Dundee. How are you, Jackie?
Wow. I'm good, thank you.
The rock
Indeed,
tick of
Susie,
Australian law.
Susie Quattro. Take that as a massive compliment. I love Susie Quattro.
Yeah, there you go. I knew you'd like that. Anyhow, Jack, it's great to have you on. And the main reason we've got you on today is to talk about two incredible doctors who have been taking on the system. Now, these ladies should be enjoying retirement, right?
Yes,
Tell us
absolutely
about
they should.
tell us about this wonderful couple. They're not a married couple, they're sisters. Give
Yes.
Paint us a picture of these two amazing women.
They're twin sisters who turned 80 this January. Now, they're from the Mallee and they're extremely staunch women. These two ladies, I just have the utmost admiration for. They are setting an example for Australians. They are standing up in the courts, trying to correct and, I guess, make the government accountable for creating unconstitutional acts. So everything within both of their cases has exposed a lot of corruption, bias, perverting the course of justice, etc. And they just keep going in and fighting. They will stand for no rubbish. So they are just amazing. I'll tell you something interesting that I just worked out the other day. I had a meeting with someone and he said, gee, that means they were born in 1945. Now, the interesting thing with that year is that that is the last time in 1945 that an Attorney General actually did his job and took a matter into the High Court. And of all the cases, it was the Attorney General of Victoria versus the Commonwealth in 1945. And it was after that High Court matter that we had the referendum in 1946 and Section 5123A came into play. So I thought, how is that for a coincidence? And that section of the Constitution in particular is where it says, after medical and dental services are noted in brackets, so as not to authorise any form of civil conscription. So I thought that was a bit of a coincidence there. But we've got both of these ladies are fighting AHPRA and the Australian Medical Board. As we know, these which are meant to be regulatory bodies set up by government are actually corporations, we've found out. But regardless, they've gagged doctors across the country, and any doctor that tried to stand up and, I guess, adhere to their Hippocratic oath, they suspended. So both have had the claim that they are a danger to the public. So for writing lawful exemptions, which was in Dr Beverley's matter, she's had 40 court cases to date. And as we've gone over all the determinations, etc., in her court cases, it's just astronomical. They have a blatant and utter disregard for the Constitution. This is the lower state court. So Dr Beverley's been in the magistrates, the Supreme Court of Appeal. And you can see the collusion there. They're just whitewashing everything that AHPRA and the Australian Medical Board are doing. But Dr Beverley is fighting away. She's got lots of matters still to come, and she won't let it drop. But for the moment, we're concentrating on her sister, Dr Beverly. This is what I really need to get out today, I suppose. Dr Beverly had a matter heard in the High Court on the 9th of April, and it was a directions hearing in front of Justice Beach Jones, who is the newest member to the High Court Justices. So this is the Section 109 that I spoke with you guys, that must be a year ago, I can't remember, on Club Grubbery. But she is attacking this, or her arguments are covering two very important subject matters, shall I say. So, as we know, Section 109 of the Constitution is if a law of the state is inconsistent with the law of the Commonwealth, the latter shall prevail and the former, to the extent of the inconsistency, is invalid. So Dr Beverly is taking the defendants in her matter are Eastern Health, who she was employed with, who she lost her job with because she refused to take this jab. And the other is the state of Victoria for the Public Health and Wellbeing Act and the sections that the state government put in there to mandate vaccination as a requirement to work. So Section 109 comes into play because of, we've got Clause 5 of the Constitution, all right? So I'll start with there. So this is the operation of the Constitution and laws. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state. So that's your bottom line. Clause 5 determines everybody, all parts of the Commonwealth, courts, judges, etc. Everyone is bound by the Constitution and under any law made by the Commonwealth. Now, the Fair Work Act of 2009 is a federal act that was created by the Commonwealth Parliament. You will find at, do you want me to, I can actually get it up. Do you want me to send that through to you, Graham, or can you get that up?
No, not here.
All right, look, if people go to, it is Section 26 of the Fair Work Act. If you go to Section 26 of the Fair Work Act,
have you got
the Commonwealth?
If I share screen to you, are you able to do it?
Oh, no, I can't because I'm on my phone. I couldn't get it up on my computer.
Okay, all right.
But look, we'll just, as a reference point, because it's always very important that people can see, I always try, whatever I speak about, it's important for people to be able to reference that themselves. So if I go into, let me just move that to the side here, Acts. So the Fair Work Act at Section 26 clearly states the Commonwealth have made it very, very clear that this act is to the exclusion of any state industrial law. So this is where I guess the deception really is, or the confusion comes in, because people will say, well, they were the health acts, they were not state industrial laws. But what you've got to look at when you are looking at acts, etc., what they may say in form is not necessarily how they affect people. So what we say is you've got to look at how acts or laws affect the people in their practical operation or their general application, is how it is said. I'm just trying to get to Section 26 here. So at Section 26 of the Fair Work Act, it's and this is the thing, it is a massive act. And this federal act covers every single employee-employer relationship across the nation. There is no state or territory that is exempt from this. This is the act that every single employer must adhere to. So here we go. It's under Division 2, and this is called, this section is interaction with state and territory laws. So you will find at Section 26(1), they make it very clear, the Commonwealth have made it very clear, that this act is intended to apply to the exclusion of all state or territory industrial laws, so far as they would otherwise apply in relation to a national system employee or a national system employer. Now, Queensland Rail is one of the High Court cases that is a real landmark case in this area. So any employer who meets the example of a corporation within the meaning of Section 5120 of the Constitution must adhere to this Act. So basically, any employer that has an ABN or an ACN number, and I would suggest that 99% of employers in this country make that. At 26.2, the Fair Work Act has even got here, they've got the definition of what a state or territorial industrial law is. It is any general state industrial law would be one that applies to employment generally, that is regulating workplace relations. Another one is providing for the establishment or enforcement of terms and conditions in the workplace. Another is providing for the making and enforcement of agreements, etc., etc. So the Public Health Acts across the nation, all the state and territory Public Health Acts, all put conditions into the workplace. They were regulating the workplace. They interfered in what's called a foreign field, being the workplace. So they are clearly, there's no question, they meet the qualifications of 26.2 of the Fair Work Act. In their practical operation, they were being used as state or territory industrial laws. So the Fair Work Act clearly states that it is to the exclusion of. So in law, in High Court case law, this is what's called an indirect inconsistency. Now, a direct inconsistency is if a state or territory act or law would alter, impair, or detract from the operation of a federal act. And clearly the Fair Work Act could not operate as until the qualifications of a state act were met. So that was that employers could not go to work unless they provided proof that they were vaccinated. It really is a very, very clear-cut case. So the questions that Dr. Beverly is asking within her matter is, if state acts cannot circumvent the Constitution or federal law, can corporate policies circumvent the Constitution and federal law? Now, the answer to both those questions is no, obviously.
Well, that's how
and that's pursuant to Clause 5. So it's a very clear-cut case. So what's occurred? Sorry, Graham.
John, have you got any questions?
Well, it's a minefield, isn't it? I mean, the thing that worries me more than anything, Jackie, is that I mean, even High Court. I mean, here Beverly is before Justice Beach Jones. Now, Justice Beach Jones is the lawyer that was promoted to the High Court after the Kassam matter v. Hazard.
Yes.
And Justice Beach Jones is the same Justice Beach Jones that gave a keynote speech and address at the University of New South Wales about the virtues of mRNA vaccines.
Oh, I didn't know that. Very interesting.
So,
look, I understand your concern, and look, it's interesting. I went over the Kazam versus Hazard case only the other day. I was just having a glimpse through all of the arguments, and like that case, I'm telling you, that case was designed to fail, as were many of them. That matter should have been in the High Court. It should have been Kazam versus the state of New South Wales. So whether or not they went in under Section 5123A, because that's how AFL fought that. It was a Section 5123A. And, you know, I looked at continually, Beach Jones repeated throughout his determinations in that case, it is not unlawful for somebody to consent to being vaccinated prior to work.
Consent.
Now, that was the whole point of that case, is that people only consented or signed something under fear, duress, coercion, or undue influence, under the threat of loss of livelihood. And one of the landmark cases for that is the BMA case, the British Medical Association case, where Justice Webb actually states, it's an old case, it's a 1940s case. He states, they didn't have paragraphs back then, it was on page, I think it was at the bottom of page 292 and at the top of page 293, where Justice Webb makes it very clear that if somebody was forced to do something that they, words to this effect anyhow, that they otherwise may lawfully decline not to do, yet to decline would be to lose their livelihood. That, I think he said, would be civil conscription.
So, Jacqui and John, let me ask the question that if Beach Jones is hearing this, what is it that progresses a case to the full bench of the High Court? What's a case got to do to get to the full bench?
Well, what will occur in this case, you see, Beach Jones, with both the matters, we had both Rod's and Beverley's were heard on the same day there, and it was the same principles or the grounds that he remitted them to the lower court. Now, as Beverly said, they may need to be corrected in form, but certainly the final hearing or determination must be in the High Court, because Rod's, as well as Dr Beverley's matter, the remedy that is sought is to invalidate in part or in whole sections of a state act. So even though Beach Jones correctly said that the Federal Court of Australia has got the jurisdiction to hear matter between parties, yes, it does, and make determinations, and yes, it does have the jurisdiction to hear subject matter pertaining to the Constitution as well and make determinations, but only insofar as the validity or the challenge to the validity of state or federal acts is not on the table, because the Federal Court of Australia does not have what's called territorial operation. So the Federal Court of Australia cannot provide the remedy sought. Hence, it must go back into the High Court to be heard, and it will be a full bench. So Beach Jones, yes, I as we said, it can go back to the Federal Court to have any matters in form corrected, because that was something he touched on. Look, you've got to understand, a precedent has been set here regardless. This is the first time in High Court history, in Australia's history, that matters that have been brought to the court by lay people, the case is written by lay people and presented with no legal representation. This has never occurred before. It's the first time in our history. So Dr Beverley's matter has to go back to the High Court. There's no two ways about it. It is the only court that can provide the remedy. So we've actually got some template letters that we would ask Australians to send to the High Court. Beach Jones also stated that some of the grounds he gave was that the High Court cannot be distracted or diverted from its principal purpose. So what is the High Court's principal purpose? That would be to determine matters of great constitutional significance, and it would also be to determine matters that are of great interest to the general public. Hence, we would ask Australians to write to the High Court and state your name, what state you are in, and what the effect of these COVID-19 restrictions had upon you, whether or not you were forced to take a vaccine or lose your job, whether you refused to take it and lost your job. Even with employers, you can write in as well and say, I was forced under threat of penalty to make my employees get vaccinated, or the states were threatening to hit me with a penalty of $35,000 thereabouts. I'm not sure if it varied from state to state for each employee that was not vaccinated.
Mm.
Like, it's absolutely criminal what has occurred.
Yeah.
You had Scott Morrison clearly stating we cannot mandate vaccines because the Commonwealth can't. That's what the matter, the Attorney General of Victoria versus the Commonwealth in 1945 clearly established, was that the Commonwealth Parliament only has what's called a fiduciary power pertaining to anything listed under 5123A. That's why you'll see that it's all to do with endowment, benefits, pensions and services. So what did the Commonwealth government do? The Commonwealth government went out and purchased, with taxpayers' dollars, approximately 260 million doses of an experimental vaccine.
Yep.
I mean, that is the other criminal thing that we forget. I mean, we speak about, the vaccines and being forced, but we've also got to remember it was an experiment and still is, the results of which are unfolding now.
And let's not forget, Jackie, that not only did they buy those vaccines, but in lieu of Morrison saying that they were not mandating a vaccine, they went out and used their levers and their economic levers to tap on the people who they knew could do the dirty work for them, like Qantas, by bailing them out, giving them money, hand over fist, $1 billion. And so the reward for that was likely the pushing down of those mandates and vaccines in those corporate entities.
Well, the state governments, the state parliament went ahead and put mandates, requirements into state acts. And the thing is, excuse me, even though these requirements within the state and territory acts have been impugned, they are still sitting there on the books, so they can bring it into play again at any time. So this is the importance of Dr Beverley's matter. And look, I cannot emphasise strongly enough the importance of Dr Beverley's matter. This is potentially going to go down in Australian history as the greatest case ever heard in High Court history, because it affects so many Australians. It affects every single working Australian. And even though the state acts have impugned those requirements, corporations within their policies still have those requirements that you've got to be vaccinated in order to get a job here or to retain your job. So this is where Dr Beverley's matter will knock out the corporation policies as well. So it's
the way I see the whole thing, John, is that every case fought out through the federal court system has been an abject failure. Yours has failed. Kassam v. Hazard has failed. We've seen Mel McCann, the case that she's mounted now for the vaccine injured, that's failed. I mean, nothing seems to be working. So where do we go from here? If these systems aren't supporting the people, we must do something in the High Court. We must find a way to get into the High Court.
We're in there.
You're
We're in there,
there.
Graham.
So how is A. Beverly standing up? Because the pressure on her must be immense. And I get a feeling you're going to say she's tough. She's doing this really well. How can she be supported? Because if everything else has failed that we've tried in the last 5 years, and this is our only option, what can we do to help us succeed?
If the Australians can support her by donating so she doesn't have this financial burden, because this is the other thing that the court systems do. It's costs awarded against Australians, and these lower courts are absolutely corrupt. So each time you go in, like even with the directions hearing where it's been remitted to the federal court. So the thing is, it's got to go back to the High Court, as I said, because the federal Court of Australia cannot provide the remedy sought. The High Court is the only answer. And I'll say now, if you go over High Court case law, there has not been any incorrect determinations within that court to date. So as you said, Graham, what we have seen has been failures in the court. Now, even within the High Court, all of these cases, Palmer versus the state of WA, Gurner versus the state of Victoria, Cottrell versus Romanis, Kazam versus Hazard, etc. Every single one of those cases was designed to fail. None of them had the correct arguments. None of them. And the justices can only make their determinations and adjudicate upon the arguments that are presented to them. So you've got to think, when the Palmer matter happened, that was in November 2020, and I think in early 2021 they came down with their determinations. Now, that was designed to fail, and the only reason Clive Palmer remained in the High Court with that is because he came in as a resident from another state, which is ridiculous, under 75(4). But what his QC, Mr. Dunning, did, and we saw he did the same thing in Liberty Works versus the Commonwealth. And this same strategy that was used in Palmer was repeated in Cottrell versus Romanis and Kazam versus Hazard. And what that is, when you go into the High Court, you must ensure that the judicial powers of the Commonwealth have been engaged. So what Dunning did, what that happened in Kazam and the same in Cottrell was they were arguing against the directions of the Chief Health Officer. Now, the restraint of the Constitution operates upon the legislative authority, and there is case law galore on this. So the legislative authority is the Act. So the acts that are created are the legislative authority. It does not operate on the actions of the executive officers, being the CHOs, that operate below the Act. So if you are challenging, as Dunning did, as AFL and in Gurner, they challenged the directions, the actions of the executive officers. In law, that means you are assuming the legislative authority is valid. What they had to do was challenge the validity of the legislative authority, being the state or territory health acts. And if they had done that correctly, it is very clear that they are inconsistent with the Federal Fair Work Act. This is the thing. It's
Well,
not rocket science, but it's been
I don't
ignored.
100% agree with you, Jackie. I mean, there were I think the problem is the courts are against people trying to try these things. I don't necessarily buy that the arguments weren't effective. I mean, in
They
our
weren't.
in Larder v Hazard, I mean, the public health order is what was being challenged, which was an act of Parliament which gave the New South Wales Health Minister the control to basically introduce emergency powers for a 3 month period. Now, the Supreme Court and Supreme Court of Appeal agreed that that was valid.
But what was your argument? There is no argument that the chief health officers do not have emergency management powers. Yes, they do. Certainly they do.
No, it was the
What
health
arguments did
minister,
you put
not
in
the chief
place?
health officer.
But
Well,
what argument?
there was arguments based on religious exemptions, on
No.
human rights. There was health aspects. There was informed consent. There was numerous aspects to it. So I'm not saying what you're doing isn't working. I mean, we need to experiment with everything and prosecute everything to win in this thing. But I just think it's a bit unfair to say that that those people didn't put arguments forward, because they did. But the system at that lower level in those courts was not fair and balanced. And now, unfortunately, you've got one of those adjudicators that's in your matter.
No, well, he's gone now. You see, he was basically put him to the test, I suppose. He was there for the directions hearing as a single judge. When he goes back up into the High Court, it'll be a full bench.
Which he'll be part of, will he?
Potentially, I'm not sure. Not likely, because he was on the directions hearing. You see, this is the thing. This is the thing, John. When you go in and do your arguments, they will try and distract or divert you. So this is something that we say. You know, there is no question with the ability of these things, and certainly the Chos have the ability to declare emergencies. But
I
the
mean,
correct.
I'll give an example in the Kassam matter. I mean, one example. I mean, Judge Beach Jones said he preferred the evidence of Professor Christine McCartney, who had never treated one COVID patient. She was on the board of the injections committee for the federal government. She had received millions of dollars in funding to her pet projects. But he made it very clear in his summation that he preferred the evidence of her over the experts of Peter McCullough and all these other people that AFL solicitors had introduced into the court and were knocked down.
This is the reason why, John, we do not go into anything to do with subject matter or merit. Because if you start to bring in, as that case did, they will always bring in their own experts and disregard any of your expert advice. So this is why Dr. Beverley's matter, etc., is based strictly on the Constitution and federal law. All of the arguments or authorities, I should say, for her, that are relied upon in Dr. Beverley's case is High Court case law. So here, Your Honour, Your Honours, this is what you've said in this, and this case. There's no question as to whether or not the state and territory health acts were being used as industrial laws, because the definition is clear in the Federal Fair Work Act of what a state or territory industrial law is. So what did they do, these state acts? They came in and stopped the operation of the Federal Fair Work Act the employee-employer relationship of which the Federal Act is king of, couldn't operate until the qualifications of a state act were met. It is the simplest of arguments. There's no going into any subject matter or merit, and there's probably, I don't know, 50 High Court case principles and precedents that have been set that back the entire case.
So what you're saying is you didn't need Peter McCullough or anybody else.
No, not at all.
You're right. Okay.
That's absolutely beyond that. It's nothing to do with that. There is both direct and indirect inconsistencies pursuant to Section 109 of the Constitution. The State Act is both indirectly and directly inconsistent with a Federal Act. That's it. Simple.
Jacqui, have you had any chats with Augusto Zimmerman?
I went and saw Augusto. He did a presentation down here in Melbourne. But look, he's a very learned man, and I've got a lot of respect for him. But he, what I found once again, which I see commonplace occurring, is that it was a lot of talk about the doom and gloom and everything that's coming in, you know, with the World Health Organization, the World Economic Forum, and blah, 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 blah. Like, I'm sick of hearing it. We know what is going on. What is the remedy? What is the remedy? This is what we need. So, yeah, he didn't come up with any remedy.
So, at the moment, tell us where Beverly's at.
Well,
in this matter.
Dr. Beverly, we're waiting for the hearing date in the federal court. So there's a little bit going on behind the scenes as well. So what's occurring is Rod Cullerton is there's a Section 40 being taken up into the High Court from, as I said, both Rod and Beverly's matters were remitted to the federal court. So more than happy for the federal court. Both of them are happy for the federal court to correct any issues in form that there may be, but it certainly can't have the final judgment because it doesn't have the jurisdiction to provide the remedy sought. So the Section 40 is removing from Rod's matter the questions of law to the High Court, which we know the answers to already. Does the Federal Court of Australia have jurisdiction to invalidate state or federal law in whole or in part? And no, they don't. So that means both matters will go back up into the High Court for final hearing.
And where are we seeing this on a timeline?
I don't know. Hopefully hopefully within the next month.
So we're on the cusp of finding out who's right in this situation. And if Dr. Beverley's right and what you're saying actually works the way it should work, then we could see dramatic change in the whole landscape.
Yeah, look, the other very, very important thing for Australians, I think, to like comprehend, and I think nearly everyone will. What is the greatest control mechanism that you could place upon people? One of the greatest things to control them, to get them to do something that they wouldn't normally do. That is take away their livelihood. So if the government is there threatening that you can't provide for your family, you're going to lose the roof over your head. I mean, like, that is one of the most devastating things you can possibly think of occurring in reality, isn't it? That's the stress that we all live under, you know, trying to keep a roof over our head and food on the table and all the bills paid. So that is how this low-life government, this is what they did to Australians, put them under that high-pressure stress to take part in something that they could lawfully decline to do, but to do so would mean loss of job. So when Dr. Beverly is successful, like, these arguments are irrefutable. There's no question to them. This is why they're dreading hearing this, I'm telling you. There is no escape from these arguments. The state and territory public health acts did put conditions and regulations into the workplace. That's not even a question.
Yeah.
They did. So they did operate as state and territory industrial laws. And in doing so, the employer-employer relationship, you couldn't go to work unless you met the qualifications that the health acts across the nation were met. So that's the facts of it. This case cannot lose. And when Dr Beverly wins this, this will also stop the corporation policies doing the same thing. The states will never be able to do it again, which means the government have lost the chokehold they had on Australians to force them to do something. It is the greatest control mechanism they have ever used to date.
Well, we've got to give this every chance for success then.
Well, yes. I mean, can you see with what I have just sort of read out, like with section 109 is very, very clear.
Mm-hmm.
Section 26 of the Federal Fair Work Act is very clear.
Yep.
So there's no comparing witness, experts and this or that. This is Clause 5 of the Constitution. All courts, judges, people of the Commonwealth, notwithstanding the state, any laws of any states are bound by the Constitution and federal law, any law that the federal parliament makes, Commonwealth Parliament makes.
Well,
there's no getting out of this.
It's challenging, like Rod Culleton's been saying it for years now. It's challenging jurisdiction, and that's what seems to be failing all over the place. And I can see John's argument. A lot of people have invested an awful lot in doing this, into trying to see justice served.
Yes,
but justice is not being served for whatever reason. And so, if all of these matters are failing, then we have to find out why they're failing. It's like it's the same approach as we've got with the vaccines. If people are dying, if people are getting brain tumours, turbo cancers, if people are presenting the hospital in rapidly increasing numbers with heart complaints that they weren't seeing before, then we have to explore what's the reason. What's the reason that the health system is failing? We need to explore, Jacqui Dundee, what is the reason that the Australian judicial system is failing? And once we identify that, then how do we remedy it? That's the thing. Once we identify that the vaccines may be causing death, what can we do to remedy that? We've got to sort that out in order to get health right. We have to sort jurisdictional issues out so that we make sure these things never happen again. So we've got to explore every avenue. And to disregard your argument that you put forward here today, in my way of thinking, is like us saying, yeah, well, we don't know what's causing all these excess deaths, but we know it's not the vaccine. Does that make sense?
Yeah, I don't think we can disregard it, Hoodie. I think we have to hold on to it going forward. There's no question about that. But from my point of view, I think the major problem has been we've found that the courts are not free thinking. They're not prepared as they once were to examine facts and to look at things independently. They've been captured. Let's say it for what it is. I mean, the Chief Justice of the Supreme Court of New South Wales issued a memorandum 3 days before the Kassam trial that said everyone that entered a courthouse had to be vaccinated. Now, if the Chief Justice is saying that to everyone that has to enter a court, how can then Beach Jones then, how can you be independent?
You should have been disqualified.
It's ridiculous. I mean, it's so, I hope Jacqui, has success. I mean, everyone out there does. I mean,
well, Dr. Beverly, yeah. Well, look, it's a clear Section 109. This is the thing. It's clear. It's very in your face. the laws of the state and territories are inconsistent with the federal law. That's it. That's the argument.
Well, we're going to post in the description. We'll be posting the links that you've sent to us, Jackie. We'll
Thank
get
you very
that
much.
as soon as we can. We've got a minor technical issue in that the guy who does all this for us fell off his roof the other day and broke several ribs. He's coming out of hospital today or tomorrow, but we'll get this out as quickly as possible. If you could keep us updated, we did want Dr. Beverly to come on, but for obvious reasons, she doesn't want to prejudice her case at the moment. So, you know, she's keeping her powder dry, and we totally understand the reasons for that. But please give her our best wishes. And,
I will.
she's a champion, and we can't wait to interview her when she's able to speak without prejudice. So let's look forward to that day. And thanks, Jackie. You do a powerful amount of work. You don't get paid to do what you do. You do a lot of research, and you're looking for solutions, and that's what we've all got to do. You're looking for remedy, and we thank you for that. So we'll get this out as soon as we can. John, any final comment or statement?
No, just say good luck to Dr. Beverly. I mean, it's an amazing story of two, wonderful Australians, 80 years of age, both doctors. We interviewed, was it Beverly?
Yes, Beverly.
Yeah, what an amazing Australian, and
They're gorgeous.
I think she cried tears at the end of the interview. She was
Dr. Valerie says we were womb mates.
Womb mates. How good's that? 80 years ago. 80 years ago.
They're just gorgeous. I love them to pieces. They're beautiful, beautiful women. So
let's put a prayer on them, shall we, before we go?
Yes.
Lord Father in heaven, we just ask for your blessings on Beverly and Valerie Peers, two courageous women. And we know that they're both Christ-loving women. We know that. They've admitted that. And not that they have to admit to it. They embrace it and they're proud of it. And Lord, as are those of us who believe in you, we just need all the guidance we can. And Lord, we're talking about a country that's strayed away from its Christ-centered Commonwealth Constitution. It has. And Lord, it was that constitutional document was founded by Bible-believing Christian men and women who decided that these things had to be protected. And that document is being disregarded, as so many other things are in this world. So be with us and guide and lead us, is our prayer in your precious name we pray. Amen.
Amen. Yes.
Johnny, you've often been heard.
Of Almighty God, the Constitution was put in place.
That's it. Johnny, you've often been heard to say.
You just couldn't make this stuff up.
Yeah, God bless you, Jackie. Will you keep us in the loop?
Oh, look, absolutely. Thank you so much for having me on again. And yes, God will be with us and Dr. Beverly. This is the thing. It will all come out in the end. I've got no doubt, because we are operating in the light and in truth. So that will always win. So it's a challenge and it's a battle, but we're put through these for reasons, I suppose. So maybe to wake more people up.
We know there are people out there who are not short of means. We know that. And we know that you do a lot to support various causes and cases that are going on around the countryside. But this one, I think, is one that we want you to get behind because we've got to give everything a chance, and everything else so far has run into a dead end. So please consider, and all the links will be in the description. Don't forget, it's a great country, Australia, because you live in it. Be kind to each other, and we'll see you next time on Club Grubbery. Bye for now. Whoops.
Thank you.
Thank you.